Welcome back. One thing I do need to do, is Herman here? Okay. One thing I do need to do is acknowledge Witness to Innocence. So we partnered with Witness to Innocence earlier this year because we share in their mission of elevating the voices of the exonerated. Sharif works with Witness to Innocence, which is a local Philadelphia organization, and Jenny Sheeks and their executive director, Herman Lindsay, are both here. I hope you'll introduce yourselves to them and help promote their mission as well, because as you can see, the power that the stories that the exonerees tell themselves is really unmatched. And to Sharif's point, for those who engage in this way, it is a form of agency, it is a form of dignity, and it is a form of therapy for many of them. So we're indebted to be here working with you and Witness to Innocence, and thanks so much for your help in helping that session to happen. Yeah, exactly. We could get some applause going. So we're going to talk now about collaborative conviction review projects, hearing from practitioners who actually do the work. In 2015, the Quattrone Center released a report that looked at the then 25 conviction integrity units around the country. A conviction integrity unit is a unit within a district attorney's office that works to evaluate plausible claims of actual innocence. And we did a review of the then 25 of them. And the point of that review was kind of to say, well, hey, do we think this is going to catch on? Is it really going to be a thing? And if it is, there was some skepticism about whether prosecutors' offices could be counted on to actually review these cases, in good faith. And so, how would we know, and how could communities, how could practitioners who wanted to do it well think about it, and how could communities that wanted to verify it was being done well verify it? So we released that report. And from there, we actually, Marissa Bluestein, who you heard from earlier, and Kia Hayes, who is here with us, have done some really amazing work with the Bureau of Justice Assistance's funding to create a community of conviction integrity units and innocence organizations around the country, because this is one of those situations where historically adversarial roles are actually coming together in theory, for a common good that everybody supports. Navigating that can sometimes be tricky. Navigating that in good faith can sometimes be difficult to discern. And so we're going to talk about some subsequent research that's happened in the space as a result of those collaborations. And I'm going to let Kia introduce all of our panelists, but Kia and Taylor Migliori, who've done all this work, please take it away.
Thank you. All right. Thank you, John. I'm going to advance. You can see our panelists as well. And identify them. But thank you all for coming. Thank you all for staying, especially after lunch. We have a great panel for you. I'm going to kind of go down the line and introduce everybody. We have some wonderful panelists today. Starting off, my name is Taylor Migliori. I'm the research project coordinator here at the Quattrone Center. I work primarily on CIU research. I've also done this evaluation project with Kia, and I do some other things here and there as the Quattrone Center needs me. But Kia?
Hi, everyone. So I recently have taken another position elsewhere in Philadelphia, but for the purposes of this, I'm going to be talking as if I'm still here because I love being here and I'm happy to be back. So I was the evaluation manager for the Quattrone Center, working with CIUs and innocence orgs.
I'm Marla Mitchell-Cichon. I'm the former director of the Cooley Law School Innocence Project in Lansing, Michigan, and where I currently serve as counsel.
And afternoon, my name is Robyn Frankel. I'm the director of the Conviction Integrity Unit at the Michigan Department of Attorney General. I was hired there in 2019 to start the unit. Prior to that, for 30 years, I did criminal defense, trial, and appellate work.
Good afternoon. I'm Ann Garant. I'm the managing attorney for the Cooley Law School Innocence Project with Marla.
Great. So we are going to start off with a poll. So if you want to take out your phones, go ahead and scan this QR code, or you can go to pollev.com and just put in collab123. I'll give you guys a second to sort of scan that. All right. Everybody's good?
So the first question, who is in the audience? We want to know if you are part of an Innocence org, CIU, freed or exonerated person, academic, criminal justice research person, government, journalist. Get a sense of who's here. Okay, mostly academics, that tracks.
Yeah, that makes sense. All right. And the next one.
Next, have you been involved or have you collaborated in some capacity with a CIU or CRU?
All right, at least half.
Okay, 12, it's complicated. Hopefully, maybe 15, 14, maybe we'll get some more information about how so. Next slide. Next poll question. How would you rate your experience working with a CIU, CRU if you've collaborated with them in the past?
You can be honest.
Right.
These are anonymous.
It's complicated first.
Maybe, yeah.
And his name.
For the bad
That's the
and
example.
for the bad and very bad folks, please get in touch with Marissa Bluestein.
Yeah.
See how she can help.
All right. Great. And then these are some word clouds.
What potential benefits can you see coming out of a collaboration of this kind? And so if it's a multiple word answer, please put an underscore in between. Efficiency, faster, exoneration, yep. Prevent errors, education. Freedom,
Lots of exoneration.
yeah. A lot of exoneration, a lot of speeding up the process, making it more efficient.
Ooh, closer to the truth.
Minds. Documents, yes. Great. What perceived barriers prevent you from working collaboratively?
Distrust.
Trust and distrust, yes.
Lack of access.
Adversarial posture. Complicated. That's a complicated person.
Ooh. Place-
Bureaucracy, cultural differences.
Politics.
Great. Yeah.
Very, very interesting.
You.
Thank you all.
Who said 2? Thanks, everyone.
All right.
Oh, now it's me.
All right.
Yeah, so just for folks who don't know, I'll talk a bit about who we are and what we do at the Quattrone Center for CIUs and Innocence orgs. So we are technical assistance and training providers with BJA, and that's basically a fancy way of saying that we help you make your projects more successful, make your operations more successful in reviewing old cases, identifying cases of innocence, working with prosecutors or innocence orgs, helping. So when district attorneys are newly elected and they want to get a CIU off the ground, we help them with that process. We have templates and policies on our website, which are available for use. We have all kinds of toolkits on how to support victims and survivors. One thing we frequently hear from CIUs is that they want to know how their practices compare to those in other jurisdictions, and so we help create community, getting CIUs in touch with others in their state or across the country so that they can share ideas. We have a monthly webinar where we feature subject matter experts on a variety of topics. Marissa, do you know what the topic is for next month? Oh. Great. And we post those videos on the website, which is convictionreview.net. So please, and also if anyone is not on the email list to get the information about the monthly webinars, please see Marissa and she'll get you added. So more about the growth of CIUs. Still a relatively new phenomenon. In 2000 there were 0. By 2016 there were 27, and now there's over 100. And more than 50 were created in the last 5 years. As John mentioned, we documented that growth in 2016. And on to the next, thank you. So with the growth of CIUs, it's a high risk, high reward. There's a lot of opportunities to collaborate with Innocence projects. And because CIUs work outside of the traditional adversarial system, an Innocence project working with a CIU can offer hope for wrongly convicted prisoners who otherwise wouldn't have an avenue for relief. They can also give Innocence orgs access to records and help move the process forward more quickly than if they were to be litigating this on their own. However, our inbox is still filled with stories of Innocence orgs and CIUs who, are frustrated with lack of trust, lack of transparency, and, whose collaborations, struggle to get off the ground. In 2022, we published the guidelines for collaboration and engagement to give guidance to prosecutors and defense lawyers who are seeking to work together to investigate claims of innocence. And so we'll talk a bit about our evaluation study. This is the first qualitative research project of its kind looking at prosecutor and defense attorney cooperative relationships. And looking at how did those relationships fare? Were they successful or no? If they weren't successful, what were the challenges that they encountered that prevented them from being able to efficiently look at old cases? And how can we use those stories to help provide tools and strategies for others entering these kinds of collaborative projects? And so we interviewed 28 CIUs and Innocence orgs, which represented 14 collaborative projects. It was myself, Taylor, and Charles Loeffler. And now Taylor is going to talk a bit about the methodology.
Great. So like Kia said, this was a qualitative interview project that we conducted, again, with Charles Loeffler. He's in the criminology department here at Penn. So I'm going to get into sort of the methodology of how we did it, the who, what, the where, when, and the how. So starting with the who, like Kia mentioned, all of these grantees were recipients of a BJA grant, whether in the year fiscal year 2018, 2019, or 2020. And the actual grant name is right there. It's the Upholding the Rule of Law and Preventing Wrongful Convictions program. So each pair was a grantee and a sub-grantee in each of those years. And basically what the grant seeks to do is to support that sort of collaboration between these two entities, a CIU or a CRU, and a wrongful conviction review entity or an innocence organization. Basically, they review cases with post-conviction claims of innocence. That's not necessarily narrowed into a certain kind of case. It's kind of up to the grantees to decide what they want to focus on, but that is sort of the broad, the goal of the grant. And going into the what, we've already mentioned this was 28 qualitative interviews. Each of these was done over Zoom. I think we had maybe 1 or 2 in person, but for the most part, these were done over Zoom. They took about 60 to 90 minutes each. Each grantee got an interview and then each sub-grantee got an interview. So during the process, none of the information that we gleaned from the grantee was used to inform the interview of the sub-grantee. Everything was kept very separate to conserve the integrity of each of those interviews. And each one kind of focused on 4 main sections. So we talked about individual career paths, project origins, development of the collaboration over time during the grant period, and then we asked them to reflect broadly about challenges and successes within that collaboration. Not sure what that is. And like Kia said, we had 14 CIUs or CRUs. We interviewed all 14 of them. And then we also had 14 wrongful conviction review entities. We also interviewed all 14 of those. And here's kind of a cool graphic of the where and the when. So each color represents a different fiscal year. So FY 2018 is in blue, 2019 is in red, and then 2020 is in green. Sorry, I keep stepping away. So this way you can kind of see geographically where each of the offices fall. We are definitely Eastern Seaboard kind of biased, but we do have some people in the middle as well. And you'll see that some of the dots actually have different colors around them. So in Michigan specifically, there's a blue dot with a red outline. That means that that site actually received a grant in both of those years for both of those colors, if that makes sense. And then same thing in Florida, same thing in Maryland. So you can kind of see where everybody falls during those years. Okay, and getting into the actual how, I wanted to include some interview question examples. So we did follow sort of a rough script for each of these interviews, just so we had the same information gleaned from each sub-grantee and grantee. But obviously, with the way that interviews are structured, we sort of asked questions based on what the respondents were saying. So while we did follow a script, we did sort of veer off depending on what they wanted to talk about. But the first one is individual career paths. We wanted to learn a lot about the individual, where they're coming from, how they got into conviction integrity work in the first place, if they have sort of a prosecution background, if they have sort of a defense background. That was really important to us. And then also in terms of project origin, so how the project was actually created, what they wanted to sort of look into, how these individuals even met and applied for the grant project together. That was of interest to us as well, and what they sort of expected to get done during the grant period. The next section is project development, so how the actual working relationship was developed over that time period, how trust was built, how those relationships were created, and how they handled any tensions, because inevitably there's something that you disagree on in this work, and we wanted to know how they sort of navigated that to be more successful in their grant project. And then the last section was sort of broader questions, reflecting back on successes, reflecting on challenges, just to get sort of a very overarching view of what was successful in the collaboration, and then also advice that they would give if anybody else was thinking about doing something like this. And then getting into the how, we've already sort of covered step one, which was just the interview. So we conducted the interview, we recorded it, we downloaded all of the audio files, and then we uploaded it into Trint. And Trint is an AI-powered transcription software website. It did a pretty good job. I think it was like 95% accurate, but obviously we had to go in and clean it up because it didn't get everything correctly transcribed, especially names and things like that. But once we were done cleaning it, we actually went through and redacted everything as well. So any sort of identifying information was redacted, names, titles, geographic location, case details, anything that could be sensitive information was completely scrubbed, just to kind of, again, preserve the integrity of the interview. And then lastly, we coded them. So for the academics in the room, you probably know what I'm talking about. For everyone else, there's a way to thematically code qualitative data to turn it into sort of quantitative data. So we used NVivo. And this is a software where you can upload the transcripts, and then based on sort of themes that you find in those transcripts, you're able to quantify how many times that theme showed up. And you can bring this over all 28 of our interviews that we did. So if that kind of sounds abstract, I do have an example. So this is just a fictionalized example. Obviously, I'm not going to use a real transcript, but this is based on sort of what people were responding to us with. So this would be an excerpt from a CIU chief. So I was previously a criminal defense attorney in my state. I was a public defender right out of law school, and then I joined the State Innocence Project after about 10 to 12 years at the Public Defender's Office. I was a staff attorney there for about 5 years, and then I saw a job posting for a CIU chief for a unit that had just opened in my state. So I applied, I was hired, and while it was definitely an adjustment to, quote, switch hats, I've really enjoyed it so far. So this is sort of what we're getting when we upload the transcript, and this is what we're doing thematically. So this first sentence we're going to code as professional background defense. Like I said before, we did have a section that asked about the professional background of all of our interviewees, and this is a way to quantify what they said, see how many people came from this defense background, see how many people came from a prosecutor background, and then we can also tie it to their actual identity. So this CIU chief had a defense background, and that's important to us. And then we can go further with the second sentence here, or clause, I guess. This is specifically an innocence background. So we wanted to code not only defense, but also specifically innocence, because this is post-conviction and wrongful conviction research. So we'll code this second section as professional background innocence in purple. And then this next section actually talks about a CIU that was newly formed. And that was also important to our research question, just in terms of seeing how many of these grant projects went to newly formed CIUs and were seed funding these CIUs, versus how many went to CIUs that were already established, that already had funding at either a county or local level. And that was another thing that we were sort of looking for. And then lastly, and again, this is fictionalized, so there's like 4 examples in one of these paragraphs. Typically, people don't have that many things to code in one thing. But for this example, we'll put that aside. But this last sentence is something that we looked at in terms of identity and role expectations. There is a lot of crossing the V in terms of post-conviction work. So for example, this CIU chief had a defense background. We did want to talk about that a little bit and see if there were any role confusions, role expectations, how they navigated that. And that was something else that we would sort of code for here. So this is sort of how we would go about each transcript, doing it for all 28 cases, and eventually we would have a quantification of who came from a professional defense background, who came from an innocence background, who had role confusion, those sorts of things we were able to quantify doing it this way. Okay, and based on that coding, we've established sort of 3 emerging themes. We're not totally done with the coding process, so these might change, but these are things that have really stuck out in the interviews that we've done so far. And there are 3 C's, which I thought was catchy. So we have commitments, capabilities, and constraints. So getting into the first one, commitments. We found that there was this sort of shared commitment between CIUs and IOs. Obviously, this is usually the catalyst for getting into a grant project like this, is there is this shared commitment of wanting to free the innocent and the wrongfully imprisoned or the wrongfully convicted. And this is usually shared between the 2 offices. So this was something that they sort of both agreed on. It's usually in their grant proposal. It's the purpose of their project. But there becomes a difference in the terms of which organization has which bottom line. So for the most part, innocence organizations tend to have a single bottom line. They're here to free the innocent. They want to get innocent people out of prison. That's sort of their goal, and that's what they're, working towards every day. So we have a quote from a senior staff attorney talking about inculpatory results and how that can sort of be unexpected, and it goes against their organization's bottom line. So they said, quote, "I was really surprised by how many inculpatory results we got back. I couldn't believe how many people were hollering and saying, yes, 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 test. Like we had 2 guys who originally their profile was not confirmed and they consented to testing. And not only did we confirm that they were the true perpetrator of that case file, but they also got a CODIS hit." So there's this tension between wanting to free the innocent and having that be your single goal and working in one of these grant projects, and suddenly you get an inculpatory result that goes against, everything your organization works for. On the other hand, CIUs or CRUs sort of have this double bottom line. So yes, they really want to free the innocent, they want to free the wrongfully convicted, but if they get an inculpatory result, it's not the worst thing. So we have a quote from a CIU chief that says, "It's a successful review when we find that we have confidence in that original conviction as well." So there's not this sort of tension between what the results kind of say. So there's even the last quote, "We're not the exoneration unit, we're the conviction review unit, and they're quality control." So there's this difference of the single bottom line and the double bottom line in terms of what these organizations are sort of committed to. Okay, moving on to our second C is capabilities. And we've discovered that these organizations have complementary capabilities, which kind of explains why they would want to work together in the first place under a grant project. But IOs have very credible expertise. They've been doing this for a very long time. It's what their organization does every day. They have the experience, they have the attorneys in the office that handle cases like this. So there's a quote from a CIU chief here that says, "I think they're a tremendous resource. This is what they do, and they do it well." And when they had this kind of novel thing arise where, their gut feeling was, "I don't think that this should be used in a case," they reached out as the local expert, sort of asked what kinds of cases the Innocence Project had worked on with this particular issue, and they were very helpful. So they have this sort of expertise and this experience that CIUs might not necessarily have, especially if somebody in the office doesn't have either an innocence background or a defense background. And then CIUs tend to have more access, whether this is to unredacted documents, whether it's to evidence, whether it's to law enforcement. They tend to have a little bit better access to the court process, and they have authorities within that court process. So like Kia was mentioning, CIUs can kind of be a different route for people to take for post-conviction motions, and this is certainly true for CIUs and CRUs as well. So the first quote is from a CIU chief. For post-conviction, most, if not all, jurisdictions have very high bars for what evidence you're even allowed to present within a post-conviction motion, and the purpose of a CIU is to sort of remove that onerous adversarial requirement to get to the truth. So while the IOs bring sort of expertise and experience, CIUs can use that expertise and experience with their access and authorities to get cases moved through and potentially get exonerations. And then the last quote is from an Innocence organization legal director, who's basically saying that this sort of post-conviction work is very rare still within the larger legal system, within the larger judicial system, because there's usually this expectation that there's two opposing parties. So somebody will file a motion, the other party will file, an opposing motion. So when you have a grant project like this, who, the CIU will say, we reviewed all their evidence, we've looked at all of their witnesses, and we concede legally, we agree that this person should be let out. It's really hard for a judge to go against that. So that's where this sort of complementary capabilities comes in. Each party brings their own expertise to the table. And lastly, constraints. So these grants have seed funded, like I mentioned earlier, and started CIUs as well, but they also can offer a sort of workaround to some sort of constraint within an office that's already been created. So the first one is a funding constraint. So in some cases, the county funding in that office is going towards, the trial unit, the prosecution of cases. And in this instance, they were saying that their elected can justify that spending because they're preventing crime. And the post-conviction section, or the CIU, can't necessarily make that claim. So it's really hard to get funding to that office in that way. So the grant can offer sort of a workaround to that funding, so they don't have to go through that sort of application. And then on the other hand, it's sort of related, but it's a little bit different. Bureaucratically, it's very difficult to hire within a CIU or within an office. So this respondent said, absolutely, I would prefer to have, help in-house. I would love to hire them in my office. But realistically, it just makes so much more sense to get the money from BJA and give it to an Innocence organization that I trust, that I know they're going to do the work. They have the expertise. They know how I work. We have a good relationship. It's a lot easier to do it that way for some people than to go through sort of the bureaucratic hurdles of getting people hired in their office. And then the last constraint, and I feel like this is something that we need to say, collaborations are only going to be as good as the collaborators within that partnership. People work differently. People have personalities that may or may not vibe with each other. So every grant project is going to be constrained just in terms of who the people are involved and how much they want to work towards, the ultimate goal of the grant project. But that is just a constraint to keep in mind. Okay, with that academic mumbo jumbo, we are going to get into our trenches per se. We have some wonderful people from the Michigan Attorney General's office and the Cooley Law School Innocence Project here with us, who are going to give their personal account of their grant project, give some real world insight into sort of what they did, how they worked out. They're still, I think you guys are still on an active, okay, they're still on an active grant project, so they're definitely the people to talk to.
Thank you so much, Taylor. And so, one of the things the Quattrone Center says about collaborations and, gauging success is that it's not always about exonerations to make a successful project, a successful collaboration, but you had 5. And so that's, incredible. 5 people who were wrongly convicted and, thanks to the work of your collaboration are now free and out and living their lives. And so that's great.
Yeah, these are the 5.
And so,
Yeah, absolutely.
Connecting to our From Anguish to Action theme, if you could tell us a little bit about these individuals and their cases.
Let me start by saying that all 5 of these guys were connected to the Cooley Innocence Project and to our office. Some started with our office, and then we brought Cooley in. Some started with Cooley, and then they brought cases to us.
Okay.
Also, the University of Michigan Innocence Project or Clinic was involved in at least one of these, the DeJesus brothers. They represented one of the brothers, and Cooley represented the other. I didn't add the total number of years. Did either one of you ladies add the total number?
Someone could do it.
Don't
We
make
have a
me do
math
math.
Let's do it. Gilbert Poole, 32 years.
32.
If they're listening.
Corey McCall, 16.
50.
George DeJesus, 25. Melvin, 25. Lewis Wright, 36.
134?
34.
134 years between these 5.
All of these folks have been released in the last 4 years, in the last 4 years, as a result of our working together. Now, the Michigan, the Attorney General's office had one additional recommendation for relief that wasn't a collaboration with Cooley, but was a collaboration with the University of Michigan Innocence Clinic, and that resulted in the granting of a habeas. But these were all as a result of our connections. And I'm going to just jump to Lewis Wright for a minute, and I know Marla and I can talk about Lewis Wright forever, but Lewis Wright was the last exoneration from our office, the most recent, January of 24, February of 24?
November of 23.
23, okay, maybe it took till 24
Time, time flies when you're spending time with me, Robyn.
But Lewis Wright, the interesting part about Lewis Wright, well, there were a lot of interesting parts. Lewis Wright went to prison was arrested in January of 1988 for the breaking and entering into a home and the rape of an 11-year-old child. The day following the incident, he was contacted at his apartment, brought to the local police department, small local agency. His interview was not recorded. He did not write out anything in his own hand, but allegedly he confessed. This confession was, again, not reduced to writing or recorded in any way, shape, or form. And let's add that Lewis Wright also had some known mental health deficits. Fast forward, case gets to court. The first thing his lawyer does is send him for a forensic psychological review because she's concerned about his cognitive disabilities. The report comes back that he's fine. He's competent, he can proceed. Case goes forward. The lawyer files a challenge to his statement. It is scheduled for what we call in Michigan a Walker hearing, which is a hearing on the voluntariness of the confession. The day before that hearing, the lawyer files a supplemental request for a forensic evaluation because of her concern with her client's decreased decompensation while he's been sitting in the county jail. She can't communicate with him. She can't get his focus controlled. She wants another eval. They go to court the next day. First thing that happens is the judge says, those are the same things you said the first time, counsel. And the Forensic Center said he was fine. No, denied. No new psych review. Then they have a Walker hearing, and surprise, surprise, the judge finds that confession was completely voluntary and it's admissible. The trial is scheduled for the following week. 20 minutes after the denial of the Walker hearing, Lewis Wright enters a plea. No contest? Of no contest. 20 minutes. Of course, remember, his lawyer the day before said she was concerned about her client's cognitive disabilities and his ability to proceed, but nonetheless, she pleads him guilty. 3 weeks later, he shows up in front of the judge for sentencing, and he says, I don't know if he used the word coerced, Marla might remember, but he essentially says, I'm not guilty, I want to withdraw my plea. I feel like I was forced into this plea, I'm not guilty. And the judge's response was to say, if you don't sit down and be quiet, I'm going to have you removed from the courtroom and gagged and then brought back in for sentencing. So Lewis Wright stopped. And he was sentenced to 35 to 80 years. And he never stopped contending that he was innocent. His cognitive disabilities were again and again corroborated by the Department of Corrections, even though I don't think they engaged in any affirmative treatment. The Cooley Innocence Project gets involved, and I'm going to let Marla pick up when you first got involved.
We got involved very, very early on in our project, which started in 2001. And so we were originally established to do post-conviction DNA testing. And since that time, based on some of these collaborations, we've expanded our work to broader forensic work. And so we don't have time to really get into all the details of it, but Mr. Wright was not eligible in Michigan to ask any court for post-conviction DNA testing. We had actually rejected his case a couple of times, but we had a Department of Justice grant prior to the CIU collaboration grants where we actually requested funding to support the review of guilty plea cases. With our goal at that time to identify a handful of guilty plea cases in Michigan, to work with the local prosecutors to get those that evidence tested and to exonerate. So he was one of our early on clients where our goal was simply to get post-conviction DNA testing. When we were working on the case early on, which was I think around 2014-15 was when we were doing the guilty plea project, we were not able to convince the local prosecutor to agree to DNA testing for us. So we were very limited in what we could do. So after the CIU came into place, it was one meeting. This evidence is material. We tested items from the rape kit. We all agreed that that evidence should be tested. And it was quite miraculous, the DNA results, because not only did we exclude Mr. Wright very definitively on more than one item, but there was sufficient data from the testing to put it into the data bank. So it was a very strong exoneration despite Mr. Wright's so-called confession and his subsequent guilty plea. So this case really, not only did it free an innocent man, but the broader policy implications that Mr. Wright's case stands for are truly important, and that never would have happened without our collaboration with the CIU.
And some of what we were able to do, the lawyer who was lead on this case is Lori Montgomery, who's not here today because she's been ill. But Lori took the lead on trying to find the actual evidence. Early on, I think it was in 2014, the Cooley Innocence Project had worked with local law enforcement, and local law enforcement confirmed they had the evidence. Miraculous. That in and of itself was miraculous. But by 2019, when we came into being, somehow that evidence was lost. And for years, the local police department insisted either they couldn't find it or they didn't have the time to look for it. I'm really not quite sure what it was. Until one day when Lori Montgomery called the local police department and said, you know what, it's not destroyed. We know it's not destroyed. So how about I'm gonna send my investigators out there tomorrow and they will comb through your evidence room with you and see if we can find it. The following morning, before our investigators could even get in the car to head out there, guess what kind of phone call we got? Lo and behold, they found the evidence. And then because Lori and Marla had worked well with the Michigan State Police Forensic Lab for some time, and they have all developed good relationships, Lori was able to expedite the testing, and I think it was tested 2 rounds through in like 2 to 3 weeks.
It was quick.
Yeah.
It was fast.
Can we have that on our next case?
It was real fast. Then, of course, and this goes beyond the collaboration, although it sort of involves, then we had to fight with the local prosecutors. Carrie and I talked about it earlier, having to deal with getting local prosecutors on board. We are a statewide unit, and so we're very conscious of not wanting to take local jurisdiction away from a local prosecutor. You know, we can argue all day over whether the state attorney general has the authority, the legal authority to make this decision, but I know that my boss doesn't want to do that and stomp on the toes of local prosecutors. These are their cases. They're their constituents. So we went to the local prosecutor who said, well, yeah, I know it's a DNA exclusion, but he confessed. And it took us bringing in our criminal bureau chief in my office, who's like the top criminal prosecutor in the state, to get her involved in order to convince this guy. First, he simply agreed to bond. We won't talk about that. And so we got Marla's client bonded out, and then it was 2 more weeks.
Yeah, it
I
was
think.
quick. Because I think someone from my office kept sending you harassing emails.
The key to collaboration is it's okay to punch the opponent. The key is, and you guys said it time and time again in polling, is trust. But I'm going to add one more, and that is you got to remove ego. Because if your ego is too involved, then you don't trust the other side because you're too worried that they're going to take your credit. And ultimately, the credit doesn't really matter. And it can't be about our egos, none of us, because ultimately it's Gil Poole and Corey and George and Melvin DeJesus and Louis Wright. It's not about us, but it is about the trust. And I think that's what's kept us going all this time.
Thank you so much. And so, his case, really illustrates how a collaboration can bring access to documents, to evidence, physical evidence, to the decision makers and expediting the testing. As I worked at an Innocence org, and I know that without having somebody on the prosecutor's side to see the value and to help move things forward, it won't move forward. And so, it would have taken probably several more years.
If at all, just before I forget, Marla mentioned one of the problems that the Innocence Project had trying to move this case was that in Michigan, to this day, guilty plea cases are not eligible for statutory DNA testing. And so, thankfully, because we have this collaborative agreement, we just stipulated to it. Now, again, we looped in the local prosecutors. From the very beginning, Lori would email the local prosecutors and say, hey, we want to do this. We're willing to take responsibility. We're going to take on all the expense. Let us know if you want to be involved or how involved you want to be. And quite honestly, I think that they had so much on their plate, they were just as happy to let us take it and run with it. And so they didn't oppose our DNA testing. And it was because they had the background, we had the access, and the combination of the two had the relationships with the state police.
So if we can back up for a little bit, and Marla and Robyn, if you could tell us a little bit about how the collaboration was conceived, because I believe
Marla forced
Marla was
me.
Yeah, I have a problem. It's that I want money to run the office, right? So I was the director at the time, and I have a lot of experience writing grants, and unfortunately, and some days it's fortunate, and some days it's unfortunate. Sometimes it's fortunate, sometimes it's unfortunate. We've had a lot of success in obtaining grants, and one of the big constraints that we have in our particular office is we're not a public institution, Cooley Law School. So even though we're a DNA clinic, we can't apply for the Bloodsworth grant. So as the former director, I got pretty creative about approaching grants, and I have had some bad grant collaborations, if anybody wants to talk to me afterwards, because what Robyn said is totally the key. I collaborated on a Bloodsworth grant that was literally a nightmare. and it was
A federal grant for DNA testing.
yes, and so you really need to know who you're collaborating with, right? And that you're going to be able to work together professionally, as well as maybe already, I mean, now in retrospect, we didn't do this all the time, but in retrospect, maybe even have some guidelines, and sometimes in writing guidelines, right? Because I mean, it is a business relationship, right? We wrote a grant with the Wayne County Prosecutor's Office, which was the first CIU in Michigan. And so we had already done this type of collaboration with Wayne County. And when the State Attorney General's Office started their Conviction Integrity Unit, and the Bloodsworth solicitation was coming up, I was like, I need to be best friends with Robyn Frankel, the new director. So unlike Valerie Newman, who was the Wayne County CIU director, who I knew from my years of innocence work, essentially, in Michigan. I've been doing that work since 2002. I didn't know Robyn, but I knew of Robyn's reputation, right? So not only did I know that Robyn was a very accomplished criminal defense attorney, and that she had post-conviction experience, which was huge in my mind, but she also had a really great reputation as a person, right, and as a professional. So I went to Robyn and I said, let's write the Bloodsworth grant together. Again, our stories are really long. I can't go into it, but the bottom line was at the 11th hour, we figured out that it was not going to work out for my office to get any of that money. So talk about egos and pride. I had to swallow my pride, and I literally said to Robyn, okay, I'm going to go back to the office. We're going to rewrite the budget. Your office is getting all the money, and we're still going to collaborate with you. And that was probably one of the best decisions that we made, because they were a new unit, and we were able to develop that relationship. And it was then, fortuitously, that a lot of the conviction review grants were starting to come out, where, as we all know, and by the way, I do not necessarily agree with this, there's a favoritism towards these collaborations, right? So we got to test things out. I looked really good, I was like, tell Dana, Dana Nessel, tell Dana I said hi, because they got a good amount of money to do this work. And then they hired my DNA attorney. By the way, see me after the presentation about that.
With your blessing, I might add.
Yeah, I drove her to the interview. Okay, so we all sound like we're very close knit, and it's a love fest. But and sometimes it is, but we've had some challenges along the way. But getting the funding, but you have to know that it's going to be worth the collaboration. And I think our instincts were right, despite some of the growing pains that we had. So they got the money. We tested out our collaboration. We built on our prior collaboration with Wayne County. So while we were in the honeymoon phase with the Attorney General's office, we were in the growing pains stage with Wayne County. We were finding out certain procedures and protocols weren't working, so we had to change those. And then, of course, they're separate units. They have separate areas of coverage. So the issues that we had working with a local CIU versus a statewide were different, and we had to overcome those challenges. But the centerpiece of it all was that we were all committed to the success of the projects and to these individuals, right? That we were all working for the same goal, and that's never wavered, despite a few fistfights.
They were Marla's fault.
Yeah, I think we had a clarification for Lewis Wright. You can correct me if I'm wrong, whoever submitted the question. But how long did it take for the collaboration to release Lewis?
Once we got the DNA result, 3 weeks.
Yes.
We got him out on bond in less than a week, and it was dismissed 2 weeks later. I'll explain that. Chuckle later.
Right.
But so 3 weeks.
Yeah, it was very good.
It was amazing. It was miraculous.
And once we found the evidence, again, we were able to get the testing expedited only because of our collaboration with the CIU. Even though I have a 20-year relationship with the Michigan State Police, I've gotten them to expedite testing in just a few cases by my request, right? Because you all know if you do any forensic work, we have to keep the community safe. We've got to prioritize the front end cases. So even if you have a good working relationship, they're not typically going to put an innocence case on the front of any forensic testing line.
And I'm going to shout out to Lori Montgomery because she's watching, that it was because of the work Lori did that got it tested so incredibly fast.
But what about from when he applied to?
Oh, that was years.
That was years, because again, remember, he would have probably originally applied early on in our project because he was convicted in the late 80s, and we would have rejected him. And I don't, again, our experiences, people reapply to us all the time because our mandates change, and because why not? I mean, I would reapply too if I were innocent, right? So, and we always treat those reapplications with some care and consideration, right? So, we accepted Mr. Wright's case when we started actively wanting to review guilty plea cases, even though we knew we didn't have a legal way for testing, right? And we worked actually pretty hard on his case to try to convince the local prosecutor. So as Robyn said, we found the evidence. We, wrote a letter and all these things, and basically they told us to get lost. So the case was never officially closed for a period of years. We just kept struggling with what we could do with it because we didn't have any new evidence. So we couldn't file a traditional post-conviction motion. We couldn't get the DNA tested, which was so important to the case. And we knew it was a very weak case against Mr. Wright. There was no identification of him by the victim or anyone else for that matter.
Another case that is a good example of expediting the process is Gilbert Poole. He was in our office for, I believe that Marla alone worked on the case for 18 years.
Yes.
And when the collaboration came into effect, it expedited that process, and it still took multiple years after that. But 18 years versus a couple years is a big difference. So without that collaboration, I'm not sure if Mr. Poole would be out.
He would
today.
not be. He would not be out, in my opinion. One of the real challenges in Mr. Poole's case was that there was some of the key evidence used against him was a bite mark, and unfortunately, Google his case. It's actually a very interesting case. Every court, this either with or without me, Gilbert Poole litigated his case from the day he was wrongfully convicted, and he was in and out of state and federal court multiple times on the bite mark. And unfortunately, ultimately, the federal court held that the admission of the bite mark was error, but that error was harmless. Which, just even saying that out loud today, I get that feeling that we all get in our chests, right? Like the pain of that. And so in many ways, Mr. Poole's case was not a court case anymore. And because I had worked with him for 18 years and I knew he was innocent and I wasn't giving up, we were sort of working behind the scenes of figuring out a way to go back to court when the CIU. So again, when I went to see Robyn about post-conviction DNA testing grants, I'm thinking,
Gilbert Poole. You talked about Gilbert Poole.
yeah, I'm like, I got an application for you. How about that? And that was really a complete and utter game changer. And even though it took longer, I think it took about 2 years, but that, for all the hurdles that we faced, we got denied DNA testing in Gilbert Poole's case in court, litigated the denial of post-conviction testing for 4 years before we finally got an order for DNA testing. So Mr. Poole really had gone through every court avenue, and he would not be free today without this collaboration.
Now he's got a house.
And so one of the key factors that has been identified in when a collaboration is successful is trust.
Yes.
And so, Anne, can you talk a little bit about how trust was established and, what work that's doing in this collaboration?
Yeah, I think it was helpful that the players knew each other, which I know is not always going to be the case. Lori Montgomery worked in our office before she went to the Attorney General's office. We knew her, and that's a blessing, but also it can be it can be a little bit of a problem because you know these people so well that you forget sometimes that you're on opposing sides. So I think that really helped with the trust. The fact that we had a collaboration with another conviction integrity unit prior to this helped to like we were able to see what was working and what wasn't working. Any collaboration, I think you're going to have your ups and downs, but the fact that we have people at the conviction integrity unit and at our office that truly believe in this work also very much helps with the trust aspect of it.
And you know you own it. Marla and I laugh about this now, but we had a big brouhaha over a case. And at the end of the day, I don't know which one of us called the other one first to say, I'm really sorry, heat of the moment, I'm sorry. So it's not being afraid to say when you were wrong or when you just went off half-cocked without thinking, and trusting that the other person's going to do the same. And trusting their work, trusting, you know, we know a lot about how they work internally. I feel like these guys know a lot about how we work internally. We're not afraid to share those things. We have common interest agreements on most cases so that we can directly share unredacted reports with each other. And we trust that those reports aren't going to be used in the way that we've asked them not to be used. We trust that the personal identifiable information that we need to be kept private is going to be kept private. I don't think twice about those things.
And I know if Lori were here, she would say one of the big things is to share the bad facts along with the good facts. That helps with trust too. And in the end, it only helps our client. If we hide things, and then it's going to come out eventually. And if we hide it, then that builds a wall. They don't trust us. They don't trust what we're doing. They think we're trying to hide things.
So if Val's watching, she's probably nodding very vigorously.
And you know, I think that's actually one of the hardest things on the Innocence organization side. And I don't necessarily mean that we withhold bad facts, because we don't. I mean, all the craziness is usually already out. Right. But I think that it's been much more difficult from my perspective in thinking, like working with my client in that relationship of my relationship with the client. Because as much as this collaboration with the CIA is super positive, it's not like being in court where, as much as court sucks, there's at least a structure that we all know and that we follow. And even if there's not a timeline, we can say the judge can decide whenever, or he or she can never decide, which is what a lot of Michigan judges do. I hope you're all watching. And so with the CIU, a lot of times Robyn and her team will tell me very, maybe not every, they don't hand me over their investigative reports, but they will inform me about their investigation thus far. And then I have to make a professional judgment about talking with the client about that. And also, I don't have good answers for the clients about the timelines. And so I feel that that's been a bit more challenging. And again, it doesn't help that Lori Montgomery is now an assistant attorney general who worked with some of these clients, right? So, one day they were like, Lori was my favorite attorney. The next day, no offense, Lori, I want Lori Montgomery disbarred because she's been working on my case for 2 years. So it's that part has been a challenge. I'm hoping that some of it is just growing pains and being in a new legal arena. And I don't really think that it's coming from the CIU. I think it's coming from just us doing new and different work, and not having that structure that we had before.
Thanks so much. So we have a couple of questions. They're more CIU related, so Robyn, if you might indulge folks. So one is some CIUs require the waiver of various rights by a defendant in order for an application to be reviewed. And so they're asking, why is this? Is this necessary?
We don't ask anyone to waive anything. Now, on occasion, if we want to talk to prior counsel, we may ask a particular claimant if they'd waive their right to counsel so that we can talk to their trial attorney. but in general, we don't ask for those waivers.
Yeah, and would you consider this a kind of red flag?
Not necessarily. You mean for a CIU to ask for it? No, I think everybody's just, look, the reality is this is the new world, right? I mean, you guys put it up here earlier. We've got 50 CIUs that are new in the last 5 years. So I just think that these are all growing pains and everybody's trying to find their own way. We have these monthly meetings with you folks, thank the Lord for you. And then we all meet internally in Michigan. Then I meet with another set of folks who are other regional offices. And so much of it is just finding our way and seeing what works and how it works in each of our offices.
I would just add, because I think this is related to the client relationship issue. Innocence organization attorneys, we need to educate the CIUs that it isn't really about waiving the attorney-client privilege, if we want to use that as an example. It's about our ethical obligations to our clients, and that we need, as good lawyers and ethical lawyers, to be able to have those conversations with our clients in context, right? Why is someone asking for a blanket waiver, right? So if we can educate the CIU, it isn't that we're trying to hide anything. It's not that we won't even ultimately sign one. But let's get the process started, because we know if our client is innocent that the story that's been told is not the story, right? So, in Lewis Wright's case, there were issues around Mr. Wright's belief in Mr. Wright, okay? And that Robyn is an experienced lawyer. She could figure that out without me signing attorney-client privilege and then looking at that attorney's notes if that would be relevant. At the end of the day, it wasn't going to matter. But I think our job as innocence organizations is not to be like, I can't believe they're asking for this, but to try to renegotiate that and help them understand that we're not against it, but to do a blanket one, why that can be problematic. Your client has to trust the CIU process as well.
And your client has to trust you as protecting them.
Remember,
and if they think you're selling them out, it's not productive.
and CIUs are part of prosecutors' offices, and who put these people in this situation but the prosecutor's office. So that's a big hurdle if you're asking for a blanket waiver.
Yeah. So we had another question. Could you address the impact of civil litigation in the wake of exonerations and how that impacts the future of CIUs?
It shouldn't. In Michigan, there's been a whole run of civil rights cases. They come from cases that are being reversed by courts or by CIUs. So
It's a huge problem.
it's an issue.
We need a whole panel on that, right?
There's issues of immunity. We're struggling in federal court now. Should CIU prosecutors be immune from prosecution in the same sense? And I know we're going to talk about immunity, I think, is tomorrow. But, prosecutors don't have immunity, or prosecutors have immunity from prosecution. What about a CIU prosecutor who's doing an investigation? Because prosecutors aren't immune if they take on an investigative function. What about a CIU prosecutor? That's your job, is to take on investigations, which means that allegedly or technically we're not immune from anything that we do. Then, of course, there's a plethora of civil rights cases all over the board as a result of these, but you got to get Val in here to talk about those cases.
I'll just say quickly that one of my clients who was denied in a CIU that is not the statewide CIU, and we have 4 or 5 now in Michigan, the CIU process was then used against him in the court case. By the way, the CIU process was not part of the court record, but it's a huge problem, and that actually that blindsided me when the case went to court. I wasn't expecting that, and I misunderstood some of the processes. If Val's on, my apologies, Val, but in Wayne County, if a pro se client or a pro se petitioner files a post-conviction motion and claims innocence, that motion will automatically be referred to the CIU, and that may or may not be a good thing for the client. And the judge knows that. So I know from my own experience that when I go into a case on post-conviction, the judges expect me to prove that my client is factually innocent, even though that is not the criteria in Michigan for getting granted a new trial. So I think that's a very, we'll call it a rich area that we need to continue to explore and really get out on the table for the innocence organizations. What are the pros and cons, right? There are pros and cons to everything. And just going, if you have more than one option, you have to engage your client in that process. Do they want to go to the CIU, right? So I think those are the things that we have to be more thoughtful about moving forward.
I think also, if you want to talk about the civil litigation in terms of the 1983, as CIUs, what we all need to be aware of is then our discovery becomes fodder for those lawyers. I'm about up to here with answering subpoenas and FOIAs, which has become part of my regular daily activity. The subpoena process, depositions, and again, that's the Val Newman, because Val's got years on me in doing these. But getting hauled in for depositions, they want access to our internal memos, which we are not going to produce because they're work product and deliberative process. So we've had all sorts of ongoing litigation about whether or not we can retain our internal memos, and thus far the courts have upheld that our internal memoranda remain internal. They're advisory memos to the prosecutor, to the Attorney General on how we want to proceed and what our thought process is. But it doesn't stop them from litigating the issue.
We have another collaboration question. This might be the person who's in the "it's complicated" response earlier, but what advice do you have for innocence orgs trying to collaborate with CIUs that are in name only and have done nothing, if anyone?
Don't do it.
Yeah, I mean, I don't have a good answer.
I mean, seriously, I mean, our work is so hard, right? So all of the benefits of our collaboration we are so fortunate in Michigan. We really are, right? And Val Newman at the Wayne CIU, she really paved the way, right? And now we have a very legitimate statewide, right? And we have a couple of new CIUs that are collaborating with this CIU to learn how to do the job, right? And we're really, really lucky. But if it's not legitimate, I don't see the benefit. Personally, I don't see the benefit in it, right? You are going to have cases like Gilbert Poole's case where the pros of working with maybe even a cantankerous CIU might lead to something where if you just simply can't go back to court, you have no new evidence, then I guess maybe you rough it out, and hope for the best. But you have to be very, very careful because, again, you don't know if the case I always think of it this way, if the case gets turned down by the CIU, what's next for the client, right? And because the CIU process is so different from an adversarial court process, you really need to think that through.
And keep your eyes on it. I mean, we talked before about changes in leadership, and just sort of the evolution of these CIU organizations. Again, I can't say it enough. We are all just growing. Most of us don't know who we're going to be or what we're going to be. And so leadership's going to change. That means if you don't have another option, I guess you go back. Marla said it before, right? Sometimes you just keep going back.
We have one more question. Seems to be about CIUs using cases as a training tool for prosecutors. Looking at near-miss cases, and do they use them, I guess, to train prosecutors about how wrongful convictions...
We have not, but that is one of the things, where is Marissa, that my boss wanted me to talk to you guys about before we leave, which is doing some sort of a roundtable or a summit on lessons of a CIU. I think it's something that all of us together could devise in order to put in some cohesive sort of presentation.
I think someone earlier had mentioned that we're a room of people that doesn't take a lot of convincing, and there are a lot of other rooms that we need to be in to convince those people. So training prosecutors' offices on wrongful convictions, training police agencies on wrongful convictions, the public on wrongful convictions is where we need to be.
And we don't need a lot of sleep. That's a fallacy.
Great. Well, thank you all so much. Unless there's any more questions, I think we can wrap up.
All right, thanks to our illustrious panel, and thank you for recognizing that while roles may or may not be adversarial, people don't need to be. That zealous advocacy doesn't mean being uncivil, and for setting that example, for all of us. I'm struck by a couple of times in the interrogation panel at the beginning of this, and now in this panel. I've always felt like you work in wrongful convictions, and it ought to really enforce a sense of intellectual humility, because every one of the cases we look at is something where 12 people have been absolutely convinced beyond a reasonable doubt that the world is a certain way, and then it isn't, and we can conclusively prove it. And yet, what we're talking about a lot today is the role of humility in being able to access the justice that we're all seeking, and the need to have everybody sort of be willing to say, well, let me take a look at that again. So thank you for doing that.